Good evening, and welcome to the program, Willowbrook State School, How a Lawsuit Closed the Gates of a Notorious Institution and Opened the Doors of Opportunity for thousands and thousands of human beings. This program is presented by the Historical Society of the New York Courts in collaboration with the Willowbrook Legal Project at the College of Staten Island, CUNY, New York City Bar Association's Disability Law Committee, and New York State Bar Association's Disability Rights Committee. It is sponsored by Wilkie, Farr, and Gallagher. This year, 2022, the society, which I'm so proud to be the president of, is celebrating its 20th anniversary. 20 years of preserving, protecting, and promoting the legal history of this great state. We achieve our mission through public programs like this one, educational outreach to students across the state, publications, oral histories of the bench and bar, exhibits, and other inventive ways to highlight the role of New York's courts in society. Please, we would love you all to join the society on our website at history.nycourts.gov. Tonight's event on Willowbrook State School features 4 attorneys who have been involved in this lawsuit and will discuss the filing of the complaint, the continuing nature of the litigation, and the relevance of the case today. I am delighted now to introduce to you Hal Kennedy, the treasurer of the society, our fabulous treasurer, who has really truly led the development of this event, as he and his wife are deeply involved in this cause. So thank you all so much for being here, and welcome and enjoy the event. Thank you.
Thank you, Judge Lippman. Good evening and welcome to the Historical Society's event tonight. We really thank you very much for being here in person and for all of those that are online. My name is Hal Kennedy, and I am a trustee of the Historical Society. Sitting next to me along the dais here are people that you'll be hearing from tonight, the lawyers instrumental in the lawsuit. I will introduce them in a moment, and we are so grateful for their contributions in the past and continuing to today. And we're so grateful that they agreed to be with us tonight. Thank you all. This year marks the 50th anniversary of the famous Geraldo Rivera's expose and the filing of a lawsuit that would ultimately lead to a consent judgment and Willowbrook's closure. We will be talking tonight about the lawsuit, the resulting consent judgment, and the impact they have had not only in this country, but throughout the world. As Jonathan Lippman mentioned, I too want to thank the people that are supporting this program. First, the College of Staten Island and its Willowbrook project, legacy project. The College of Staten Island now occupies the grounds of the former Willowbrook School, including many of its buildings. The Legacy Project has been running programs throughout the year that acknowledge important Willowbrook events. This is one such program. Special thanks to the Legacy Project Committee and for Professors Catherine Lavender and Norma Santiago for co-chairing that committee. And thank you to the City Bar Association Disability Law Committee and the New York State Bar Association's Disability Rights Committee for their collaboration with the Historical Society. And of course, a special thanks to my old firm, Wilkie, Farr, and Gallagher. Let me also take a moment to acknowledge some of the trustees that are in attendance. And I see that John Sifford is here, and Judge Carmen Saparic and Helen Friedman. And am I missing anybody? I hope not. In any event, and I know that there are many trustees online, so thank you all for being here as well. And let me also give a big thank you to Marilyn Marcus, Allison Murray, Dan Sierra, and Jill Shulkin for doing what they do all the time, and that is produce great programs like this. Willowbrook was where a 12-year-old girl had her teeth removed because she had a biting disorder, where solitary confinement was the answer to behavior disorders, where residents were fed food ground into a gruel and washed down with water in about 3 minutes' time. Willowbrook was a place where residents were turned into human guinea pigs to test a hepatitis vaccine with the result being everyone contracted hepatitis. Willowbrook, in a word, was just awful. Opened just after World War II, its population exceeded 4,000 that it was planned for. And by 1965, the population was well beyond 6,000. And Senator Robert Kennedy was calling the place a snake pit. In a moment, you'll see a short Geraldo video, and you'll understand why it was called that. In the fall of 1971, a courageous young reporter at the Staten Island Advance, Jane Curtin, began writing a series of articles on the horrid conditions. Because of those stories, and with the help of two staff doctors, Bill Bronston and Mike Wilkins, parents became more involved. In a very short time, Geraldo, then a young news reporter for Channel 7, was contacted by his friend, Dr. Wilkins, and told, there is a story here that you must cover. Geraldo brought his camera and snuck into Building 6. And on January 6, 1972, those terribly troubling pictures were being seen in living rooms across the country. The truth was coming out, and the story wasn't being lost on lawyers either. On March 17th, 1972, a Friday, at 3:15 in the afternoon, lawyers from the New York Legal Aid Society and the New York Civil Liberties Union, each with their own class action complaint, marched into U.S. District Court in Brooklyn and sought relief to end the madness at Willowbrook. It was the beginning. After hearings and a trial and the election of a new governor who ran on a platform to clean up Willowbrook, the parties agreed to settle. And on April 30th, 1975, they signed a consent judgment. For 50 years, the Willowbrook story and the resulting judgment have been the driving force in creating community-based residences and expanding the educational and vocational opportunities for persons with developmental disabilities. The growth of voluntary agencies and the expansion of career opportunities for those in the field can be linked to the Willowbrook judgment. Even government was retooled to accomplish the mandates of the judgment. A state agency supporting people with developmental disabilities would be created, the Office for People with Developmental Disabilities, OPWDD. Is all well today? No. Service budget cuts over the past decade have resulted in a shortage of programs and residential opportunities as waiting lists have grown. More importantly, direct support salaries have not remained competitive, resulting in extensive turnover. We have much work to do. The challenges continue. I am a parent of a woman with a developmental disability. When I think of the horrors of Willowbrook, I think how different my daughter's life might have been had she been born just 10 years earlier, in 1972 instead of 1982. She is in a beautiful community residence, not far from the College of Staten Island. In fact, when you stand on her front steps, you see the smokestack that was once a part of Willowbrook. As the crow flies, that stack is but a half a mile away. But if you measure the distance on how far New York has come in its care for those with developmental disabilities, that distance can only be measured in light years. Thank you. We have amongst us a very special guest. And I had mentioned to Dr. Bronston. Dr. Bronston is here today. And would you take a stand? He was truly a whistleblower and has been involved with the field of developmental disabilities for 50 plus some odd years. He has recently published a book called Public Hostage, Public Ransom. There are some flyers out there on the table. It is terrific. It gives you a wonderful history of Willowbrook and also a wonderful, and if that's the right word to use, probably not, but it is a history of institutionalization in America, and he offers ideas and new thoughts on where we ought to go with institutionalization in America. So thank you very much, Doctor, for being here, and thank you for all you did and all you continue to do. It's very much appreciated. So let me just take a second here. And what I'm going to do is I'm going to introduce these folks, but just very quickly because they're going to introduce themselves and they can tell a little more of their story. But sitting, let's start the beginning. This is Chris Hansen. Chris Hansen was, and he's now retired, a senior staff lawyer at the American Civil Liberties Union. He was one of the lawyers very early on in the litigation at Willowbrook, and he was also one of the lawyers who signed the Willowbrook consent judgment. Following in Chris's footsteps, if you will, was Rob Levy, Judge Levy. He's a United States magistrate judge in the Eastern District of New York. Also worked on the Willowbrook litigation, probably from about 1977 or so, is that right? 1977, 78. And he has the distinction of signing the permanent injunction that came after the original consent judgment. And next in line here is Paul Keatsman. Paul Keatsman's going to balance the program out a little bit in the sense that he was general counsel for OPWDD. He was the government side, and he also left government and then became general counsel at New York State ARC, not one of the largest not-for-profits helping people with developmental disabilities. And finally, Beth Haroulis is an attorney with the also with the New York Civil Liberties Union. Beth is the continuing lawyer in the Willowbrook litigation, and she continues to represent the class clients. So thank you all very much for being here. And with that, I am going to ask Chris if he would come up here. Oh, geez, you're quite right. Thank God we have a better director here than me. We now are going to turn to the video, the Geraldo video.
This report starts where I started 10 years ago, inside one of the wards of that New York City institution for the mentally retarded. From the original report, quote, "There was one attendant for perhaps 50 severely and profoundly retarded children. Lying on the floor naked and smeared with their own feces, they were making a pitiful sound, a kind of mournful wail that it's impossible for me to forget. This is what it looked like. This is what it sounded like. But how can I tell you about the way it smelled? It smelled of filth, it smelled of disease, and it smelled of death." End quote.
Is that typical of ward life? Yes, there are 5,300 patients at Willowbrook, which is the largest institution for the mentally retarded in the world. The ones that we saw were the most severely and profoundly retarded. There are thousands there like that, not going to school, sitting on the ward all day, not being talked to by anyone, fighting for the attention of the attendants who are overworked, trying to clean them, feed them, clothe them, and if possible, pay a little attention to them and work with them and develop their intelligence. But what in fact happens is that they go downhill.
It is a moving video. And now, Chris.
Thank you, Hal. As Hal said, I was a lawyer for the New York Civil Liberties Union. In fact, my entire career was at the ACLU. I want to start by backing up a little bit before Willowbrook. In 1970-ish, a group of employees at all of the institutions in Alabama filed a lawsuit against the state of Alabama, arguing that the conditions were inhumane for the employees. A federal district court judge in Alabama named Frank Johnson transformed the case into an employee grievance case, from an employee grievance case into a resident grievance case. And issued the first orders trying to reform an entire institutional system. That was called Wyatt versus Stickney. And the institution in Alabama was called Partlow. And it's worth we shouldn't forget those institutions in that litigation. As Hal said, in 1968, Bobby Kennedy came to Willowbrook and there was an expose and it was horrified everybody and nothing happened. When Geraldo did his expose in the early 70s, I think nothing would have happened if it hadn't been for the litigation. But there was litigation. One of the lawyers who Judge Johnson had asked to come down to Alabama to help him transform the case was a lawyer named Bruce Ennis, who had then worked for the New York Civil Liberties Union. Bruce was very intrigued by the success they had in Alabama and decided to try and replicate that success here in New York. He chose to sue Willowbrook for a number of very obvious reasons. First, it was the largest institution in the state. Second, it was pretty convenient to be able to get to. And that was a relevant consideration for those of us who were doing the litigation. And because of the Geraldo Rivera expose, it had gotten a lot of attention, and the litigation, therefore, was bound to get a lot of attention. Judge Johnson in Alabama had decided that the residents of Partlow had a right to treatment. The theory being that if you're being confined in an institution for the purposes of treatment, the institution has to pay you back and give you the treatment that they confined you for. The case in New York was filed under the same theory, and it went to a preliminary injunction hearing in 72, or maybe early 73. It was assigned to a district court judge in the Eastern District of New York named Orrin Judd. Judge Judd did not really buy the right to treatment concept. He actually thought he would be too much of an activist judge if he bought the right to treatment concept. And so what he held was that the residents of Willowbrook had a right to be protected from harm. He had in his mind that you didn't need to make the people at Willowbrook better, but you couldn't make them worse. I first visited Willowbrook on Thanksgiving Day of 1973. You're going to be seeing some more pictures of what Willowbrook was like at that time behind me while I describe what I saw at Willowbrook. When you got into a ward at Willowbrook, the day room, there was often no furniture of any kind. No chairs, no sofas, no rugs, no lamps, no nothing. There were no things to work with. There were no toys in the children's rooms. There were no games in the adult rooms. There was nothing. All of the residents were wandering around. There were usually 50 residents in a day room, certainly in the adult day rooms, and one staff person. The only thing in the entire room was a television that was on a platform high above everybody's heads and was blaring very loud. When I walked onto one of those day rooms, the residents would run over and hug me. They were often naked. They were very rarely well-dressed. And the reason they hugged me, I came to understand, was that they were desperate for human contact. And they needed the touch of another human being. The smell is hard to describe, as Geraldo said. The smell was awful, a combination of cleanser, but also urine and feces. And there were urine and feces often on the floors and on the walls of the rooms. Perhaps the most tragic rooms were the children's wards, particularly those children's wards where there were people with multiple handicaps. We went into the children's wards frequently, and there were things in those wards called, at the time, cripple carts. A cripple cart was a long platform, sort of wooden thing, no cushions, no mattresses, no softening, just straight wood platform with a little tiny lip to prevent people from falling off of it. And the residents were placed in that cripple cart all day, every day. There weren't enough cripple carts to go around. Sometimes the residents were stacked in the cripple carts, 2 or 3 deep, and they stayed in that all day. And the residents in the adult wards who had nothing to do stayed in that room all day. No rehabilitation was going on, no treatment was going on, no care was going on, no real protection from harm was going on. I remember 2 particular horror stories that stuck with me after all these years. The first was in Building 1, which was the administration building. There was one young man, late teens, early 20s, who was confined in a room all by himself, and he was tied spread eagle to a bed. He lived his entire life spread eagle on that bed, never released from the confinement on that bed. Ostensibly for his own protection. I also remember coming across a young man who I think it was in the infirmary, but I could be wrong about that, who had developed an injury to his leg. And we sort of looked at the injury on his leg, and there were bugs and roaches crawling out of his leg. The trial began in 1974. The Department of Justice joined us, and there were a lot of lawyers on the plaintiff's side. There was only one lawyer on the defendant's side. One quick anecdote from the trial: we presented a lot of the pictures like the ones you were just seeing, all in black and white and all sort of horrible looking. We then also presented a lot of pictures of people in community residences. Those were all pictures that we presented in color, and they had rugs and chairs and couches and lamps, and they looked beautiful. The government fought it vigorously, and then, as Hal said, the incoming governor, Hugh Carey, decided to settle. He sent his he had us go up to Albany to meet with his budget director, and we spent a lot of late nights negotiating with the budget director. We presented to him a document that was about 70 pages long, double-spaced, and he negotiated with us over and over and over again. At the end of it, we had a document that we had all agreed upon that was 69 pages, double-spaced. And he said, how can I go back to the governor and tell him that I negotiated all this time, and the most I got was 1 page out of the settlement? And he said, would you single space it? So we did, and it was down to 30 pages. And I don't know what he told the governor. I don't know whether he told the governor he cut it in half or not, but that was his solution to the problem. You will notice if you look at the consent judgment that it is virtually all about institutional standards. There's very little about community residences, although of course our primary thrust from the very beginning was to empty Willowbrook out and put people into community residences. It's overly institutionally heavy because frankly, we didn't know how to write something that would get the state to develop community residences. We set up a thing called the review panel. And the review panel's job was to monitor compliance with the decree, but also to help the state develop methods of creating community residences. And the review panel, in my mind, is the reason this case was successful. The review panel, in my mind, pushed the state very hard, and at the same time, somewhat anomalously, developed a very good working relationship with the state. And the review panel members and staff had the expertise to get the job done, and it was they who pushed the state to get the job done. Also, the state hired some good people in that era, and that helped as well. After the consent decree was signed, for the next 3 or maybe 2 or 3 years, 3 or 4 years, there were a lot of court hearings, but they were primarily driven by the review panel. The review panel would make a formal recommendation, and then the state would say no, and then the judge would have a hearing about it. Those were very active. They were very successful. And once again, it's my view that the review panel was responsible for a lot of the progress we made in that era. We started having some problems. The review panel was abolished by the state legislature, and the case got more complicated. And that's when I got out of it and gave it over to Rob.
Can you show that first picture? Just the first picture. There it is. Is that the person you were talking about?
Don't remember. I honestly don't remember.
Okay.
I don't think so, because he's more clothed than I would remember.
So there was more than one. Well, why are we here tonight? We're here tonight because a tremendous civil rights victory, a sea change occurred in our country. And it occurred, I think, at the start of the Willowbrook case, and it's still occurring. It has to do with the rights of people with intellectual disabilities not to be segregated from their communities, not to be treated as worse than prisoners, convicted felons. In fact, there are Supreme Court decisions that actually give more rights to convicted felons, for example, to outdoor exercise, than to people who are involuntarily hospitalized because of a mental disability. We're here tonight, I think, to try to commemorate what happened and try to understand what it was. And I'd like to start by saying that we just represent the lawyers in the case. And the lawyers are just this much of this big a case, because the parents, families, the residents, so many other people who were involved, the monitors, they're the ones who really did so much of the work in this case. We did what was necessary to make things, to keep this case in the attention of the federal courts and to keep the courts involved so that you all could do your work. And so one thing that I hope we'll be able to do at some point is those of you, and I see many of you who have more knowledge about this case than I do. It would be great to all sit around and talk about what it was that made this case work and what needs to be done in the future. My feeling is, well, let me tell you, my first day at Willowbrook, this is the first thing I saw. It's looking through a keyhole in a seclusion room. And to me, it's a symbol of what Willowbrook was like at that time. I think if you'd see the photos that Chris showed are pretty much what I saw at Willowbrook, except it was less crowded. But the idea that the only way we could see what's truly happening inside at Willowbrook, the isolation, the abandonment, is through a keyhole, was a real symbol of what was happening. Parents couldn't visit their children on the wards. They weren't allowed to go on the wards. People were truly isolated, not only in the bucolic setting of Staten Island, isolated from their communities in an institution, but isolated from the family members who wanted to come visit them there. And that was the true segregation and the true loss. So I'm going to go spend a little bit of time talking to you about what happened legally, but I think I could probably summarize that in 2 minutes. I'll try to drag it out a little bit to make it more interesting. But I want us to really see and understand the reasons why institutions are not good places for people. And I'm going to show you photographs that were taken at Willowbrook, but also in other institutions around the world where people are in the same situation. And I'm going to read you a statement from someone who was in an institution in his early life and learned to be articulate enough to explain to us what it was like. And then I'm going to mention very briefly what some studies that have been carried on in Romanian orphanages to show the effects of institutionalization on children especially, and hopefully leave you with the thought that no child should ever be placed in an institution. Certainly those under 3 years shouldn't be. And children should be placed in families wherever they can be and in supportive areas. So I was the third generation of lawyer in the Willowbrook case. I joined the litigation in 1977. I was just a year out of law school at that time. And I was newly hired as a staff attorney by Chris Hansen at the Mental Health Law Project. I had read no cases in mental health law, and Chris said to me on the day I was hired, "You are now one of the 5 leading experts in the country on mental health law." I believed him. I think there were only 5 of us, just by virtue of being hired. I'd never heard of the Willowbrook consent decree or been inside an institution. Most surprisingly, and I think this is a metaphor for what happened to many of us, I had never been told that my mother had a sister with Down syndrome who had lived in the same house with her until she was 8 or 9 years old. And then she was placed in a large institution in Minnesota, about 60 miles away in Faribault, Minnesota. And that she'd never told me that my grandmother had packed her into their car, their Buick, and driven her down to the institution every 2 weeks to visit her sister. And I was never told that my aunt had died before I was born. In fact, no one ever spoke of her until I was grown up. And until I came home and said I was working on the Willowbrook case, you wouldn't believe what I saw. And my grandmother's face turned ashen and said, "Do you really think it was that bad?" Because she'd never been allowed on the wards. Now, how could it be that I would not be allowed to see my aunt or know about my aunt, and that my family would be so ashamed? There was a stigma of intellectual disabilities. There was the isolation, the segregation, so much of it. And I remember someone was giving a speech about this when I was just joining the Willowbrook case. And he said he thought that the greatest driver of change in the way we look at people with intellectual disabilities will be the Education for All Children's, EHA, Education for Handicapped Children's Act. I forget the exact name of it, but it's called IDEA now. 94-142, great. And that was that so that children like me would go to school with people who had intellectual disabilities. We would actually see them in our schools, in our communities, and other places. We wouldn't be afraid of them. We wouldn't think they were the other. We would see them as people who were just like us. And when we show you the photographs of Willowbrook, we're showing you evidence, but we don't show you that these are people like us in those pictures. They're seen as the other, or people who are treated like the other. So I'm going to just allow to flow by as I talk photographs that were taken in institutions around the world to just give you a sense of who some of these kids were and adults were who were in institutions, so that we can feel that these are real human beings and the reason why they shouldn't be in institutions. So I joined the Willowbrook litigation in what I think of as stage 2 of the litigation. The consent judgment had just been signed with high hopes and the full support of Governor Hugh Carey. It required the state to close Willowbrook and place its residents in small home-like community residences within 6 years. The consent judgment also established detailed, quote, steps, standards, and procedures for the care and treatment of Willowbrook residents, as Chris said. And that would include staffing ratios, medical care, and strict safeguards against abuse and medical experimentation. At the time the lawsuits were originally filed, there were virtually no community residences available for people with intellectual disabilities. Some parents were so desperate to find care for their children that when the admissions to Willowbrook were closed, they agreed to have their children placed in the hepatitis B unit that Chris was telling us about. And most of them were told that the children would be injected with the live hepatitis B virus. Some of them weren't. And I received phone calls from people saying, aha, I just read in the newspaper what happened at Willowbrook. Is that what happened to my son? Shocking. As a result of these experiments and the unsanitary conditions at Willowbrook, a number of the Willowbrook residents became hepatitis B carriers and suffered discrimination. As a result of that, there was litigation about that in the school system. Despite the consent decree and the diligence of lawyers like Chris, change did not come easily. The signing of the consent judgment was only the first step in a long and painstaking process, which ultimately took 3 generations of attorneys, now 4, over 18 years to develop. There were 18 years of intense monitoring and litigation before Willowbrook was finally closed. In all, there were over 40 district court decisions, 7 Circuit Court of Appeals decisions, and a number of preliminary injunction hearings, several contempt hearings, and in 1982, during stage 2, a 30-day trial. This is after the consent decree had been signed. A 30-day trial in front of a judge who was in his mid-80s, Judge Bartels, one of the heroes of this case, all after the basic legal principles had been established in the consent judgment and agreed upon by the state. Throughout 20 years of litigation, the state of New York repeatedly found itself in violation of court orders, at times balking at its commitments, and too often stymied by its own inefficiency and the magnitude of the task. I worked on the Willowbrook case for 17 years and was lead counsel for the last 10. It was an education and it changed my life. Even though I may be saying things that aren't entirely flattering about the state, all of us were friends. And we all understood that we were working towards the same goals. We just thought that we were going to reach them in different ways and at different speeds. My first trip to Willowbrook was a shock. 3 years after the consent judgment was signed, I still saw residents who were naked or dressed in rags. Many were sitting on the floor, rocking back and forth with nothing to do. The smell of urine and feces that Chris described was still overpowering. I won't forget a young woman who was lying on a gurney. Her face was covered with flies and she couldn't do anything to take them off. I have a photograph of that, which I spared you of. I also remember that we went at night and there was a toilet training program for people during the day. I know, Paul, you might remember this program, Alfat. And the whole point was training about toileting during the day. The staff would follow up at night to make sure that the toilet training worked well. But what we saw was the staff followed up by locking the doors to the bathrooms. And so the people who had been in the training program during the day actually walked up to the bathroom doors and, unable to go inside, did their business outside. It was a very demoralizing thing. I think it was demoralizing for the staff as well. By the time I joined the litigation, it was clear that the state was seriously out of compliance with the consent judgment's basic standards of care. Willowbrook was unable to provide the basic necessities of life: food, clothing, shelter, medical care, freedom from unnecessary restraint. It was also unable to meet deadlines for moving residents out of Willowbrook into the community. As a result, in or around 1981, plaintiffs filed a motion to compel compliance with the consent judgment and to appoint a special master. Chris was the lead counsel at that time, and he's going to be a little embarrassed when I say this, but I think he was a master at putting together a large complex civil case with many lawyers, thousands of pages of documents, and many witnesses. And I've been involved in many trials as a judge and with some of the best lawyers around. And no one did it the way Chris did. He really is just a master. The state counter-moved and asked to have the consent judgment modified, a consent judgment that they had agreed to, but they asked to have it modified for reasons which were not as clear to us, but mainly because they couldn't comply with them, possibly. Well, and what happened was Judge Bartels wrote a long decision in which he found that the conditions at Willowbrook were terrible and found that there was no basis for modifying the consent decree. The Second Circuit Court of Appeals agreed with Judge Bartels about the special master, but disagreed with him about modifying the consent decree and authorized bed placement in institutions of up to 50 beds in place of the smaller bed sizes that we were talking about, the community residences. The next 10 years of our work at Willowbrook was taken up with trying to undo the harm that the Second Circuit decision had caused and working with the state. And to the state's credit, many people who began to work for the state began to share our view, which we think is the right view, of how conditions at Willowbrook should be and how people should be placed in smaller facilities. And so as time went on, and ultimately, I would say 5 or 7 years later, the commissioner of the Office of Mental Retardation and Developmental Disabilities actually agreed that there should be smaller facilities built. And I think that's the time that Paul was particularly involved. So one of the lessons, what were the lessons that we learned through this litigation? One of the lessons was that in order for a system to be transformed through litigation, a paper victory, in other words, a consent decree or a judgment, wasn't enough. It took enforcement and monitoring in order to make sure that the conditions in the judgment were followed, but it also took the attention of a court and the patience of a court to stick with it in order to make sure that all those provisions were followed. Believe it or not, the Willowbrook case has been in the Eastern District of New York for 50 years. 50 years of a court case. It sounds, if someone were to say that to you, you'd think that that was ridiculous. But it was the only way that we could make sure that the rights that were guaranteed to the residents of Willowbrook would be honored. And Judge John R. Bartels was the judge who oversaw it for most of that time. Judge Raymond Deary, who you probably have heard about as the special master in the Florida Trump investigation, is now the judge who's taking it over. I want to give you a few words about what ultimately happened. Let me just read you very briefly about the effect of institutions on people confined in them, especially children. This is the testimonial of Robert Martin, who is a member of the UN Committee on the Rights of Persons with Disabilities, who described his experience growing up in institutions. I often wondered why I ended up in the places I did just because I was born with a disability. I was put in a large institution when I was just a baby. I was put in lots of different institutions. I didn't get any love in the institutions. You didn't see much love in the photographs. My life in institutions meant I personally had nothing and no one to call my own. I adopted cats and made them my friends, but then was moved and lost that friend. Children raised in institutions learn that good times don't last and people and pets come and go. The result of this is very negative. We can struggle with how to relate to people. I've lived in places where there was no privacy and nothing to do. People stayed in their pajamas all day, rocking backwards and forth, much the way Chris described what he saw. And we were not treated as individuals. In fact, people said we all looked the same. There was violence, neglect, and abuse everywhere you looked. People were hosed down, left in their dirty clothes, put in isolation, and had things taken off them. I learned not to trust people and to just try and survive as best I could. The violence and abuse that was happening around us also taught us that it was okay to behave like that. People with power over other people are easily corrupted, and behind closed doors, the human rights of others are often violated. Living in an institution taught me that I was a nobody, that my life didn't really matter. How much time do I have left? Okay. So,
I can overrule her.
okay. I'm almost done. Yeah. I'm going to let Beth talk about the permanent injunction. Okay, but let me just tell you very briefly about the studies done by Charles Nelson, Nathan Fox, and Charles Zina, studying the effects of institutionalization on Romanian orphans. They found that institutionalization has severe physical and mental health consequences for children, including the brain size and brain weight, depending on the kind of interaction they've had with others. IQ scores and brain development. Secure attachment to a caregiver is a key to mental health. Having a consistent caregiver to comfort a child in stressful situations is critical to the child's emotional development. 8-hour shifts and staff turnovers work against this and create a reactive attachment disorder. In a way, the studies corroborate what Robert Martin said about his life and experiences. So the permanent injunction isn't as important as the original decree. Beth is going to tell us about the permanent injunction. It was negotiated with the help and the, I think, joyful participation of Yulin Hao, who was the commissioner at the time. And it created 3 things that I think are critically important. Number one, the right of Willowbrook members, class members, to receive services for the rest of their lives, not a sunset provision the way many court decisions are these days. Number 2, a court that will actually enforce those rights and keep its jurisdiction. And number 3, the extension of what was called the Consumer Advisory Board, and we have Ann Neubauer here, who is the heart and soul of the Consumer Advisory Board. It provided advocacy and representation and monitoring for people who didn't have relatives to take care of them. Those were 3 components that we thought were absolutely critical and deal breakers in a permanent injunction, and they were given to us. So I'd like to end by telling you a little bit about the permanent injunction hearing. There are many heroes in this case: the parents and relatives of the Willowbrook class members who never gave up, the lawyers, and there are many of them, the parents, the family members, the court monitors like Ronnie Cohn, and so many others. I can't name them all. And many of the people at OMRDD who were committed to the ideals of the consent judgment and helped right many of the wrong, in my mind, were heroes as well. But the unsung hero of the case is Judge Bartels, who at age 95 continued to preside over the case with a firm hand as he had for over 17 years. Without his tenacity and perseverance, there would still be a Willowbrook today. It's difficult to imagine another federal judge, although Judge Deary might be that judge, who would have devoted the time and energy to oversee what at times must have seemed an impossible task. I'm going to close by mentioning a time when Chris and I were in the Second Circuit Court of Appeals with an appeal. I believe it was an attorney's fees decision, but one of the judges in the Court of Appeals looked at the docket sheet, and we were sitting next to him. I don't know if you remember this. He swiveled around in his chair, so he wasn't facing us anymore. He looked at the docket sheet and he said, 75 docket entries in this case. I would never allow that. So thank you.
Thank you very much, Paul. Now we get to hear what the government has to say in rebuttal, or maybe not. I don't really have any rebuttal. This case didn't get any more defensible over the course of 50 years. I really want to thank Hank for inviting me to this. I feel like it's really an honor and a privilege. It was nice touching base with Laura again, who was my boss's boss in my last salaried position at NYCLU. Wonderful to see so many familiar faces out there and colleagues, very esteemed colleagues here. This is the best seat, coincidentally, that I ever had during any of the Willowbrook trials or anything else. I feel like I should be sitting at the plaintiff's table, like 3 chairs behind Taylor Briggs, or in some position like that, where I have to strain to see the screen. But I have to say that participating in the Willowbrook case was certainly the best thing that ever happened in my career. I don't think that every lawyer, every law school graduate gets that opportunity to participate in something that really grabs you by the lapels, and changes you, and changes your beliefs and your values. Makes you a better person. I think it's made me a better person. Maybe I'm not claiming to be better than any of you, but I'm better than I was. So before OMRDD, I worked at New York State DSS, which for some benighted reason was then the single state agency for Medicaid. I kept the Medicaid state plan. I supported the Attorney General and outside counsel in doing Medicaid cost containment litigation. And this was in the 70s, late 70s, I guess, when New York City was falling apart and going bankrupt, and the hospital system, HHC, and the private and not-for-profit nursing homes were all going under and clawing for raises in their Medicaid rates and that sort of thing. Nursing homes, of course, have been primarily Medicaid funded, I guess, since there was Medicaid, and hospitals are maybe around 30%, but that's a pretty big margin to try and stay afloat in times like that. And so then the state decided that what they were going to do is do Medicaid cost containment. So they retroactively cut rates of Medicaid providers, institutional providers, 3 months into the fiscal year. Imagine the litigation that all gave rise to. And the reason I bring this up is because the atmosphere there, although we flew to Washington and talked to the CMS administrators, it wasn't CMS then, but whatever it was, met till 3 o'clock in the morning, saved Brooklyn Jewish, this and that. But to be perfectly honest, it was sort of like a Friday night crap game in the alley with somebody else's money. Of course, the amounts of money meant that the alley was downtown, pretty near Wall Street, I suppose. But the reason I bring this up, I guess, is that there was never a thought given to the people that Medicaid benefited, to the patients in hospitals, the patients in nursing homes. And that's kind of the way the state thought about things. I don't know that anybody in the Department of Health thought that way, but I kind of feel like they did. And Medicaid, mostly for the better, but sometimes for the worse, is what really was relied upon to finance the changes that were demanded by cases like Willowbrook and the Long Island Developmental Center case and other cases like that. And I guess because somebody dug this up when we were researching defending another institution, I think it was Sunmount in this case, we dug up the fact that back in the late 60s when Medicaid came into being, guess what? There wasn't enough money to put Medicaid into all of the state's institutions and medical providers and that sort of thing. And in effect, and I don't mean to be flippant about this, even if it sounds flippant, the MR and DD institutions in the states won what amounted to a congressional coin toss over MH institutions because it was pretty clear that those institutions were in worse shape and needed the money more. So in March of '81, I interviewed for the OMRDD counsel's office. I was the first and only general counsel there for 27 years. I was, in my mind, as I remember it, I was sitting in the waiting room outside the commissioner's office, and it was sort of dingy and not crowded. There was nobody else in there, and this might be the tricks of memory, but there might have been a single tumbleweed that went by. And the reason for that is when I walked in the door was, one of the things that they led off with was, of course, this was in March of '81, they said, well, by May, the state will be in fairly massive noncompliance with its obligations under the Willowbrook consent decree. So, I've thought about that. I was thinking about that as the others were speaking. I feel a little bit like that, again, tonight. I'm wondering, like, how far down the list was I? And Hal's invitation list to come here and speak for the state reaction. I'm kidding, of course. But, it was interesting. OMRDD had never had a general counsel. There was a single counsel's office that served the whole Department of Mental Hygiene. So during the interview, I was told that I evinced little or no empathy for people with developmental disabilities and for their families. I gave snappy answers to the questions about the law and where the litigation was going and this and that, to the point that I think it was probably a close vote over hiring me after I left the room again. But I have to say that that changed, as I mentioned before, a lot over time, over 27 years, and then 5 more with NYCLU. NYCLU, by the way, some of you will recall, was eventually, I guess, an original plaintiff in the Willowbrook litigation, and they participated in the litigation itself, at least up to the time when I came on board. So what did the state do? So it wasn't certainly just OMRDD. The state actually pretty well galvanized itself to respond in the state's way, in the way that the state has a tendency to respond to everything, by making plans and clearing things at many levels and that sort of thing. Within OMRDD at that point in time, they had created a management structure to facilitate compliance. There was an Office of Project Management, which was run by Sam Koala, whom I'm sure some of you, Anna, you must remember him. He was a guy that could give you 7 ideas in 4 minutes or less, 6 of which would be pretty good, but that 7th one sometimes was a stinker. But he was very creative in coming up with ideas on what we could do and how we could address things. Alice Lynn, of course, ran the consent decree office. The executive chamber and the division of the budget were briefed all the time, as were the program committees, mental hygiene committees in both houses of the legislature. It was interesting in that most of the time these meetings took place on the 2nd floor of the Capitol in Governor's Council's conference room under the stern and unforgiving gaze of Orrin Judd, who had been the Solicitor General of the state of New York before he was appointed to the bench. So we always felt like he was keeping an eye on us. I think people who work through state government, and I see a couple of fellow former or present government employees in the room with us, understand that the division of the budget is sometimes it's the place where good ideas go to die, but it's also the hub where fiscal constraints or fiscal realities meet program ideas and somehow get reduced into what comes out the other end in governor's program legislation or responses. So now at this point in time, the deputy chief budget examiner of the mental hygiene unit of the division of the budget was a guy named Alex Rollo. Alex Rollo kept a stuffed piranha almost to the front of his desk. When you came in and introduced yourself to Alex Rollo and gazed into his cold, dead eyes, nobody even bothered to ask why he had a piranha on his desk that was like in the middle of the desk. But the fact of the matter is that he was a creative guy and also helped during the time that we made some progress on coming to terms. Resource requests went across his desk and were kind of negotiated by him along with others. So by the time I came on the scene in Willowbrook, I guess in '81, the legislative defunding of the review panel had already taken place. And eventually, after a certain amount of negotiations, the '81-'82 trial ensued. I don't know, did it go longer than '81 and '82? I know we made a lot of trips down there. We, the state of New York, started off with the Attorney General representing us, but I think between the Attorney General and me and my litigation deputy, we sensed that we were outgunned and brought in outside counsel, Taylor Briggs and his firm, LaBeouf Lamb and Associates. The state, of course, as it always does, dug our heels into some prototype facilities of 12 beds, which were the state's answer. Why I couldn't recreate that in my memory, why we were so stuck on these things, because eventually, probably not before the time of the appeal from that judgment, the whole thing was replaced with facilities that are basically 8 beds or less at this point in time for community facilities, and nobody seriously considers a 50-bedder a community facility anymore. And this is just, unfortunately, and I can't tell you otherwise, an example of a state position that was likely wrong at the time it was formulated, but we litigated it with great vigor and put people through all of this. And of course, bearing in mind that before all this came into being, the state during the early 60s had built a system of, trying to think how many, maybe 28 developmental centers into which they placed somewhere in the neighborhood of 33,000 people, many of them kids, many of them coming out through the New York City foster care system with no particular developmental disabilities, but give a non-disabled kid 3 or 4 or 5 years in Willowbrook and they'll function in that same way, which is absolutely awful. So to paraphrase Churchill in defense of the state, very mild defense of the state, you can always count on the state of New York to do the right thing after they've tried everything else. So we fought this through the Second Circuit Court of Appeals, and the Second Circuit Court of Appeals gave us some things that we had asked for that we pretty promptly began to give back because thinking evolved. Let's just leave it at that. So we went back to the negotiating table for a considerable period of time. We spent a lot of time responding to Rudy Magnone, our special master, and we spent a lot of time in rooms with each other negotiating. Now, I promised my wife that I would drop her name into this conversation every time that I took the train down to come down and negotiate with these ruthless advocates. She would send me down with a Ziploc baggie full of chocolate chip cookies, and we'd pass that around with coffee and that sort of thing. And that helped. But what really helped, and really the reason I bring that up is because we all really were, like a band of brothers and sisters in that room. We all knew what we wanted to do or the direction we wanted to go in, if not every last thing that we wanted to do. And of course, I absolutely agree in terms of the people that you meet. Not only are these all wonderful people, but Judge Bartels was a horse for the course, if you can talk that way about federal judges. He spoke like a Southern gentleman, although I guess he was from Ohio. I guess somebody told me, but must have been from Cincinnati in Southern Ohio, because he spoke like a Southern gentleman and dealt with people in that way. And I hope that I am pronouncing Judge Bartels' name correctly. Is it John R. Bartels? Is that the way it is? Because I'm still a little raw about the fact that during 5 years of appearances in front of Judge Bartels, not one time did he pronounce my name correctly. It was, so do you have something to add, Mr. Kretzman? That was one of his, at least I knew he was talking to me when he said that. I knew to stand up and say something or nothing. So other things that we learned. I'm going to apologize in advance for this, but we did learn something by things from each other by learning about it. And I'm going to say that there is no intention to be sexist about this, and it happened 40 years ago. Bear that in mind too. But we eventually learned from the plaintiffs that Judge Bartels, genteel soul that he was was very, very protective of female witnesses, of any woman that placed on the stand. And there were many women, very strong women in the case who got on the stand and testified. So the state finally, after a couple of years of this, realized that when we had bad news to tell the judge, we'd go grab Alice Lynn or somebody like that and get her all briefed and send her on up to the stand, and things went better. The judge wouldn't let Chris be mean to Alice. So the other thing I wanted to say with that, with the risk of putting my other foot into it, it just occurred to me when I was taking notes on that looking back, women really have been at the very center of all of these efforts, and they remain, it seems to me, at the very center of the community service system that exists in the state of New York now. Strong women, we don't pay them more than McDonald's pays people to flip hamburgers, by and large. We ask them under the supervision, sometimes distantly by phone, to perform nursing services to the extent that we allow them to do that. They do all this, and hats off to them. I met lots of wonderful people through representing in Willowbrook. Rob Levy. By the way, I have to say that the state hated it when Rob showed up in court with pictures. We hated pictures, especially those awful black and white pictures, because for the obvious reason, when you look at them here, Willowbrook couldn't be sanitized or deodorized. Willowbrook was Willowbrook. And the only way I think that the public in general could reassure itself that nothing like that happened in the state of New York or on US soil is by the fact that there were fences around and locked doors on Willowbrook. If you didn't have to see it, then you didn't have to confront it in your own mind. And that's the wonderful thing about the litigation and about Geraldo. Geraldo had a couple of turkeys after that, but he got some wood on the ball with Willowbrook, that's for sure. So Chris, met Mike Lotman, who I'm told is still going strong out there in the Midwest. Mike left the Department of Justice to directly litigate and oversee and act as a special master in a bunch of other institutions outside the state of New York, which hopefully made him feel not quite as bad about us. Mike, at the risk of offending him, but I don't think he's here, maybe he's watching by Zoom. Mike was also a charter member of the Rudy Giuliani Hair Club for Men. Mike was a tireless advocate and a colleague and a friend, the kind of guy that after getting you by the lapels in a negotiating session and after the chocolate chip cookies were gone, would send you a note afterwards thanking you for conceding a point that was important to him and that sort of thing. Chris, your courtroom style, one thing stands out for me was at a point in time when Taylor Briggs was cross-examining your witness from Georgia. And Taylor stood up and looked at this guy who was sort of a professional expert witness at this point in time, but had run institutions in Georgia. And so Taylor, with an innocent smile on his face, said to this witness, "So I don't certainly mean this in a pejorative sense, but isn't it true, doctor, that in this particular litigation, you speak from a position of irresponsibility?" And Chris took a beat, stood up, waved his hand and said, "Your Honor, I don't believe that there is a non-pejorative meaning of irresponsibility." Good point. Beth, I've gotten to know Beth as somebody whose phone calls I have answered steadily now for 35 or 40 years, because to be honest, I'm a little afraid not to. So 40 or 50 years later, here we are. There remain a whole lot of lawyers and legal assistance groups, some of which fund themselves, some of which are funded by the federal government, supposedly focused on people with
intellectual and developmental disabilities, but this group that I'm privileged to stand up here with, they understood that they represented people, real people, including families of people with developmental disabilities. They were willing to work and plan and litigate together as a group consistently. They know and have known since the beginning how to balance considerations of time, timeliness of performance, and that sort of thing, as opposed to the quality of the results and the outcome. And I think making law was secondary, a distant secondary to them. They knew that they were there to help people. And I'm not sure that I see the same thing today. So I think it also shouldn't go unmentioned on behalf of the state, if we're going to say a few nice things about the state, that during the course of the Willowbrook litigation, the state undertook to basically bring its entire institutional system up to basically Willowbrook standards, which I actually have no idea where it stands now, but the state did try to do that, understood what its obligation was, not just through litigation, but through what sound public policy was, fairness. So how and why did the state decide to defend the indefensible here? I thought about that a little bit, probably more lately, preparing for this than prior to that. And it always, for me, comes back to a story that took place that I saw in the Carl D. Warner Center, which were the baby buildings at Staten Island Developmental Center. I was sent down to the at that point in time, I believe that the Carl D. Warner Center, even though it was a state building and that sort of thing, it was a state building, was being run by UCP State, which was part of the reason that they eventually, shortly after that, went bankrupt and had to be reorganized and that sort of thing. But my boss, the commissioner, sent me down to take a look at Carl D. Warner because UCP was insistently tugging on our sleeves, asking for money to do this, that, and the other thing. So they sent me down there, I guess, to take a look around. I don't know. I'm not sure why me, but, to take a look around and see what was going on there, what looked like it was excessive. And so I wound up in a room with 3 infants in it and 2 staff. They were doing the most basic activities. They were doing sensory stimulation and attentive behaviors. 2 babies were engaged. The 3rd baby was getting nothing. So what do? You go home and say, they need a 3rd staff person in that room. And the truth of the matter is, there probably never will be enough resources. And I don't work for the state anymore. In fact, they're our most common defendant at the law firm where I work now, Barclay Damon, if any of my colleagues are watching. I'm not apologizing for the state, but I think the will is still there, but the resources are not. Starting back with the Spitzer campaign, 3 months before the election, he was already trying to figure out, by consulting people like me who thought they wanted to work for him for some reason, how they could depower the O agencies. His goal was to depower the O agencies, by the way, are OASAS, OMH, OPWDD, and maybe a couple of ones that are smaller than that, and how they could break down what he called, what we still call the silos that people are served in. Well, half of that eventually happened. Resources began to be siphoned away. And I do not know the answer. I think litigation certainly doesn't hurt. The Willowbrook litigation didn't hurt anybody. And it certainly didn't hurt. I can't think of another state that has a cabinet level commissioner of developmental disability services. And of course, OPWDD is one of the 5 A agencies whose commissioner get paid the most too, to defend more lawsuits if that's the way thing goes. So I guess the question becomes, the best I can do on it is not where or how can you redistribute resources. The question really is, how can you not meet clear need when you see it? How can you take one child in, or not even a child, but a person who's aging out of their educational services? How can you take one in and not take the other in? Are you really making rational decisions? Are we simply turning our eyes away from what we prefer not to look at this point in time? So thank you all for your time.
Now we'll hear from Beth Arulis, who continues to represent the Willowbrook class.
So I'm Beth Arulis. I'm a senior staff attorney at the New York Civil Liberties Union. I've been at the NYCLU since 1994. I was hired to actually replace Rob, who had departed the NYCLU, had gone to New York Lawyers for the Public Interest and become a magistrate judge. Like Rob, and as Chris said, I was seen as an expert in the field of disability justice, which was interesting because I had left White & Case, which is a very large law firm, where I did do a lot of pro bono work, and had met Rob in connection with a housing case many years previously. But in any event, just as Rob congratulated Chris on the consent judgment, I really have to speak to Rob's drafting skills, Paul's drafting skills in crafting the permanent injunction. The permanent injunction, my ragged copy of which I carry, with me almost everywhere I go, is written to reflect the time. In 1993, the federal court systems had become increasingly resistant to judicial micromanagement of institutional settings. So you were seeing school education cases stricken from the court dockets, developmental disabilities cases stricken from the dockets, and certainly psychiatric institutions stricken from the dockets. What was the concern at the time, and continues to be the concern of the judges and the federal court system, is that courts should not be in the business of making decisions that elected officials in state have been elected to make, including funding decisions. So the permanent injunction is very, almost vaguely written in terms of prescriptions. Class members are entitled to protection from harm. They are entitled to high quality residential services. They are entitled to due process. They are entitled to grievance lodging. They are entitled to incident reporting. They're entitled to high quality medical services. They are entitled to high quality habilitation, recreational services, transportation services. But there is no directive in the injunction as to how these services should be accomplished and where the courts should intervene in asserting that the state has failed to meet its obligations. So that leaves me as plaintiff's counsel a lot of wiggle room, but it also leaves the state a fair amount of space to say that in their professional judgment, X, Y, and Z should not happen. So we have been engaged in a continuous battle since 1994 to ensure that the rights of the class, and frankly, the rights of all people in New York with developmental disabilities, are respected, that people get the services that they are entitled to, that they are existing in the community, that they are not stigmatized, they are not written off and locked away somewhere. So with the injunction, we have a court that is very willing to entertain our applications to it. We are on the electronic case filing system of the federal court system. Every time I lodge a document and enter the docket number, 72 Civil 356, the electronic system says, "Are you sure?" Because There are no other, as Rob said, there are no other consent judgments that do not have a shelf date. The injunction is measured by the life of the last class member. We as class counsel are ethically obligated and we are committed to representing the Willowbrook class until the last breath of that last class member. We have colleagues and allies here. We have the Consumer Advisory Board. This was an entity that was created out of whole cloth in 1975. Antonia Ferguson is the executive director. She comes from the field. She was a staff person working with a full caseload in Neubauer, the heart of the Consumer Advisory Board. The CAB, we have class members. We have 1,759 class members living all around the state. They live in Long Island. They live in Western New York. They live in the Adirondacks. They live in the Hudson Valley in the southern tier. A lot of the class obviously live in the 5 boroughs because obviously Willowbrook was an institution on Staten Island and took in many, many families from the city. But the CAB is around the state. They are actively involved because they are in loco parentis. They were created to fill the gap that Rob alluded to, where families, because of stigma, because of shame, abandoned, were forced to turn their children over. I have seen case records relating to my clients that indicate contact family only to advise of death. Do not involve people. I get calls from siblings, nieces, nephews, grandchildren saying, we never knew we had uncle or aunt so-and-so. It is really astonishing. The CAB is in loco parentis. They stand in the shoes of the parent. They have every right of a parent to direct medical decision-making, where a person lives, what kind of activities they engage in. And they know more about the state system than the state itself because they are actively in the field, working with people, advocating for them on a day-to-day basis. There is an enormous apparatus that was created in the injunction with respect to monitoring. There's the New York Civil Liberties Union. My colleague Lisa Laplace, who I think is on the case with me. We have a colleague over at New York Lawyers for the Public Interest, Roberta Muller, who is on the case. We have the Consumer Advisory Board. They have very high caseloads. They are, by court order, able to serve 100 class members downstate and 75 in the rest of the state. But the job they do is just extraordinary. We have the Willowbrook Independent Evaluator, Ronnie Cohn. She stepped into the shoes of Rudy Magnone, who was the special master. The role that Ronnie has is a very interesting one because our injunction lifts provisions from the consent judgment as appendices. And Ronnie is able to make directives to the state that they're obligated to comply with. She has all the powers of a special master in Appendix I of our injunction. We have 2 Willowbrook consultants who are individuals who were previously with the special master's office. We've now, through the years and with deaths, got 2 new folks, but one of them is in fact a former CAB staff member who was so compelled to come back and to advocate for people. Beyond that, we have mental hygiene legal services written into our injunction. MHLS was created in the wake of Willowbrook to address the plight of non-Willowbrook class members and to advocate on their behalf. Sheila Shea is here from the 3rd Department. She's an enormously effective advocate, a fierce, fierce advocate. We partner with her colleagues in the other 3 departments as well on a daily basis, oftentimes. The work that is being done out in the field, though, is extraordinarily difficult because we have seen the defunding that started under Governor Spitzer. Governor Cuomo was intending to bend the Medicaid curve. When Governor Cuomo did his first State of the State, I think we all know that he was very big on PowerPoints. His first graphic with respect to Medicaid funding and the silo phenomenon was to show that people with developmental disabilities took up most of the state's Medicaid funding that came in. And he wanted to right-size that funding. He didn't want to increase Medicaid funding for the other populations in the state. He wanted to take monies away from people with developmental disabilities. And that's because the system that has been built over the years in the Willowbrook case, which was adopted by the state with respect to all people with developmental disabilities, is just too expensive. We have been staggering since Governor Cuomo first took office towards a Medicaid managed care system in New York State for people with developmental disabilities. It would reach beyond mere management of medical services because, as we all know, managed care isn't supposed to accomplish economies of scale and make delivery of medical services less expensive. There's no way that you can do a utilization review over a person's recreational activities or engaging in religious practice or going to a day program or living in the community in a small setting. Because of that, New York State has not been able to figure out how to put the class and the rest of the folks in OPWDD services into managed care, but it has destabilized the system fundamentally. You couple that with a staffing crisis that has been years in the making. We have the Justice Center, which was a creation of the Cuomo administration that was intended to bring all of the O agencies into a common investigatory regime with respect to incidents. So OCFS, which is serving children, obviously in foster services, OASIS, people with substance addiction issues, OMH, OPWDD, and even the Office of the Aging. That resulted in a lot of demonization of a workforce, which drove a lot of people away from providing services and coming into the system. Couple that with underfunding, as Paul said, people are paid more to work in McDonald's and they don't take that job home with them. They have driven away, a workforce which is critical underpinning to the delivery of quality services. You need hands-on, ongoing contact. I'm a lawyer. I am not a direct services person. I look at the folks who do the hands-on day-to-day and just am so in awe of what they do. They are so under-respected. As Paul said, there are a lot of women in that workforce. They are underpaid, undercompensated, under-advocated for. New York State needs to do better. We can't reach the workforce through our litigation, but together with other of the advocates, we always are advancing the need for this workforce. I can get into all the sort of areas that we deal with in addressing Willowbrook class members' rights and entitlements. They truly are, for the most part, living in the community. So they have issues around money management. They have issues around, religious practice. They have issues relating to gender expression and sexuality issues. As they age, they have aging issues. The class, when you look at the demographics, range from 50s to 100. They are the baby boomer generation. And we have various people in the Willowbrook Task Force who have always advocated for the state to be proactive about what would be an employment crunch. Everyone knows with the end of the baby boomer generation, hands-on will be needed to provide care to anyone, whether people in nursing homes, people in developmental disabilities, residential centers. The state has never, they live in the moment. No one ever gets old, not a problem. But we're facing a pretty extreme problem. I mean, beyond the workforce crisis, beyond the affordable housing problem, because it's not cheap to maintain supported housing opportunities in urban areas, particularly in New York City. We're seeing it with unhoused individuals. It's impacting all the disability communities. We try to reach that. The state has been very interesting in terms of how they approach the treatment of the class as opposed to the treatment of other people that provide services, that they're providing services to. We have been told, because of the housing crunch and the staffing crunch, they will do everything in their power to avoid impacting class members because we have an injunction. But we had a class member who was dumped in a medical emergency room and left to languish for about 6.5 months. And it was only on pain of us having a hearing before Judge Deary that the state agreed to find and fund an alternative setting for our class member. And he had to move from Albany to Long Island. He has a sister who is still living in Albany. So there's been disruption of even those family ties. I do think that we are confronting beyond the staffing and beyond just the workforce crisis, housing crisis, the funding crisis. I think we're at a point in time where there's societal fatigue with respect to people who are different, the others. We're seeing people being sort of left to languish behind closed doors. The COVID pandemic did not help anyone. There was a lack of oversight. Houses closed to protect people. Day programs shut down because it was not safe for people to come and be in congregate settings. That, I think, has pushed the system, at least from the state's perspective, into complete disaster. And there really is not an easy resolution. And it's not a resolution that we'll be able to get much traffic with the court because, you know, for all of the power of the federal court, they cannot create bodies. We cannot involuntarily commit people to servitude. Funding is critical. And I think just restoring the concept of the social compact and the need. New York State has a constitutional provision that relates to the care of the needy, which was enacted after the 1920 stock market crash. New York State is the provider of last resort. New York State has to protect people from harm, has to provide services. And we are not seeing that. It's starting to hit the class, but we know it's hitting everyone else. And when the system is deteriorating around the class, you cannot fix things for class members. So do we go to court? Yes. Do we want to litigate? No, because the litigation will be a protracted event and our class members are getting older. And for them to have to revert to the PTSD of the institutional placement is not something that, you know, we take very lightly. But there aren't currently an awful lot of avenues here, I think, through the federal court system to change where the system currently is today. So I have a consent judgment. I have the ability to rope in the voluntary providers because they are all agents of the state when they are providing services, but we can't create people. So where we are today, it's a little unfortunate. I mean, I was going to close by quoting Karl Marx. People have probably heard his quote. Because it really is, you know, it is very, I think, apropos. And you're going to say, oh, she's at the ACLU, and so, you know, she's quoting Karl Marx. But Karl Marx said, men make their own history. They do not make it as they please. They do not make it under self-selected circumstances, but under circumstances existing already, given and transmitted from the past. History repeats itself. The first time is tragedy, then is farce. So we cannot return to the farce. We cannot return to a time when people were warehoused, when the circumstances that you saw in the Geraldo video, in the photographs, are permitted to occur. And one of the problems that we have, obviously, is that we do have lots of community residences, which are turned into mini institutions where there is no oversight and vision. So we cannot go back. So I know I'm at my end point, and we are supposed to have a panel discussion. So with that, I will step aside.
We're going to have a quick discussion here, but beforehand, I've given Mr. Dr. Bronston here 2.5 minutes to say something.
I wanted to start off by saying that I'm not a whistleblower. I'm a doctor. And I have a different role in the world than either the lawyers or the whistleblowers. And my role at Willowbrook was to help organize the federal class action lawsuit, to mobilize the parents, mobilize the workers, and to deal with the issue of the people that were incarcerated that I call public hostages, who essentially are waiting for public ransom, Medicaid, to be released, but they never are. And the reason they never are is because the state receives $300 to $400 roughly a day, like ADA money in the education system, in order to, in many instances, pay off mortgages that Rockefeller and his brother put together to build the 30-odd large, 200 larger institutions around the state of New York. People were put into Willowbrook to die, and they were monetized. And if we don't understand that, that's a fundamental understanding. Secondly, us, are heading towards institutions ourselves, just like the constituency with special needs. 100% of the population is going to die in a dependent, premature, anonymous, miserable situation, unless you're very, very wealthy. So the issue that we're faced with now is to build union with the entire population and to not understand, to not fight for categorical services. People with disabilities are us. We all have disabilities. We are all exceptionally different. So the campaign has to look at climate change. The campaign has to look at peace and war. The campaign has to look at a transformation of the healthcare system towards a universal, single payer, public health dominated, rightful delivery system that fundamentally establishes a cultural revolution in the workforce. Medicaid historically funded facilities. It was set up to not Bolshevize the American family when it was first started in the 1965 area. But what that meant was that people are not talked about in the care delivery system. And we have to build a way of funding the entire new cultural workforce, health workforce in America to provide home-based, personal, direct service support. I spent this morning with Malachi McCord and his wife. Malachi just turned 91 2 days ago. He's in a wheelchair. He's supposedly in hospice, but I think he's going to make it for at least another 5 years. But the problem that they are having with direct care personnel, the lack of training, the lack of an army of those people, and the fact that they're getting pittance for money. There is enough money in America for us to afford anything human we want. When Biden puts a few trillions of dollars into Ukraine or into Iraq or into any other war that comes up or anything else they want to do, because the American government can print all the money it wants in the world, and there's no consequence to that. So I just wanted to I came here because I was told that this was going to be a presentation about the future of what the Willowbrook suit was all about. The future of the Willowbrook suit is to establish universal, single-payer, public health care for everybody in America, to end Medicaid, because Medicaid is absolutely, absolutely evil. It is evil. And I want you to read my book, which is called Public Hostage, Public Ransom. Most of these photographs were pictures that I took. I worked on the inside for 3 years. And I've tried to tell the story, the arc of the story from 1971, when I first started, all the way through the COVID period in 2022. I think you'll find it extraordinarily moving and powerful. I've spent 50 years writing it. Secondly, there's another book that was just published last week that sold in the first week 80,000 copies, called The Lost Girls of Willowbrook, written by a colleague by the name of Ellen Wiseman. She lives in upstate New York, and she's written this fiction book, and it's terrifying. You need to read it first, then read my book, and then call me up.
One of the questions that I have right away, Beth, how many people are in the Willowbrook class now? How many started and how many are in it now?
So there were over 6,000 in the class to start with. No, hold on, here goes.
5,200.
5,200, okay. Because I have reams and reams of paper. So, okay, 5,200, but there are currently 1,759 class members, 2/3 of whom are downstate, but all over the state.
So I know you have some questions or something you wanted to.
Sure. Yeah, I mean, I think people have touched on a lot of the questions. I don't want to necessarily stand in the middle. I guess maybe Rob, do you want to speak about how Willowbrook has influenced institutional settings in the rest of the world? Because we can talk about what has happened in this country, but I think it's actually interesting to see how Willowbrook has taken a.
Okay, I'll be very brief. I'd like to start by saying that in our country, institutional litigation includes not just people with intellectual disabilities, it includes prisons.
Yep.
And we're seeing terrible issues in prisons, just like Willowbrook. We've been seeing Rikers Island, and in my court in Brooklyn, we're seeing the Metropolitan Detention Center, where there was no light, no heat, no electricity, no medical care for 5 days, and we were told everything was fine. And people couldn't even see their lawyers. So that's.
I mean, with the institutional litigation, over the years, Congress has taken massive steps to eliminate courts as a venue. So we have the PLRA, which prohibits a lot of the litigations in penal settings, federal settings. I mean, it is horrific, the calls we get, what you see in the courts. Rikers is a prime example. State correctional facilities around the state. Right now, there's an enormous fight over solitary confinement and conditions of confinement, including access to medical services, women who are pregnant being shackled, gender affirming care being denied. And that's separate and apart from the massive suicide, violence, and assault by guards on individuals. And the federal courts have been preempted as an available route for redress.
I don't want it to be, I'll let you do the rest of the world, but let me, there's another area where there's a lot of litigation that's similar to Willowbrook or the prison litigation, and that's child welfare. And there have been lawsuits brought in a lot of states to try and improve the child welfare systems in each state, some of which have been massively successful, just as successful as Willowbrook has been. So it's not entirely a bleak situation. There are other successes besides Willowbrook.
One footnote to that is that Congress passed a bill giving the Justice Department automatic standing and in state institutional cases, so that you don't have to have a Willowbrook class member to be the plaintiff. There is no standing for federal cases. So the Justice Department Civil Rights Division can't step in and litigate on behalf of people in a federal detention center, but it can on behalf of people at Rikers.
Yeah.
Also a question around the world.
Around the world, or I mean, we can also talk about other institutional litigations, Wyatt, Pennhurst, Evans versus Fenty in the United States, but around the world, I think, because, I think Willowbrook and the litigation still has viability as a way to redress circumstances.
Some of the leading advocates for people with intellectual disabilities in Eastern Europe, for example, Georgia, Bulgaria, Romania, even in Kenya, are people who know about the Willowbrook case, have been inspired by it, and think about it in trying to figure out where to go from there. And there are terrible institutions in all kinds of places. I could give you horror stories, but I don't think you need them. And I think what we often see are that the horror stories, the horror pictures that people see are enough to make courts and others think that the job is done if they close an institution. And the job is only beginning, because often people are just trans-institutionalized and other segments of the population are institutionalized. So I think we need to look at this as part of a broader problem, although disability was a civil rights issue that had never really been addressed before. So I think Willowbrook was pioneering in that way. Wyatt as well.
Mm-hmm. Yeah. But I do agree. I mean, I do think we just have decentralization, and, for the state to take on the posture that they're going to break down the silos as a way to defund existing systems, as opposed to breaking down silos, achieving some efficiencies. I mean, a person with dementia oftentimes manifests with the need for behavioral supports that a person who might have a mental illness who is currently not in a treated stable state would manifest. And so there are efficiencies to be accomplished. There are similarities in terms of approach. It requires funding. It requires staff who are trained to work with a particular population. If we want to, we didn't even talk about Olmsted, because Willowbrook predated Olmsted. Willowbrook established the right for the least restrictive setting, most appropriate to the needs of the individual, measured by contemporary habilitative standards. Fast forward to 1999, which of course is in our rearview mirror, and you have Olmstead, which promises that standard to be applied to every single person who's in an institutional setting. But remember, the Supreme Court gave states a massive off-ramp. If there's a fundamental alteration, if it's too expensive, if it forces the state to make changes to its system, the state is off the hook. So the promise of Olmstead is, I think, illusory and something that continues to need to be advanced. And to Dr. Bronsted's point about unifying communities, for so long, the state has tried to play off Willowbrook class against other people with developmental disabilities, people with DD versus people with mental health issues, forget about elder folks who were segregated off into, in the pandemic, I think we had a moment where the curtain was ripped back and everyone saw what was going on in congregate settings where people were warehoused and not provided anything, including the right to live freely in a less restrictive setting. That's where I speak to the societal fatigue. We're done, pandemic's over, forget about all these people and forget about the workforce problem and forget about the fact that it's women of color from migrant communities who are supposed to do this work happily. I mean, we're hearing the state talking about trying to recruit out of the country to bring in direct care staff. Really?
I have a question, and this is sort of to Chris and Paul, but did you always think you were going to win, Chris? I mean, when you and
Yes.
Paul, I guess, did you always think you were going to lose?
Yeah, we always thought we were going to win.
And to the extent that you did, I guess, with the Willowbrook consent judgment, I mean, it's a magnificent document, and yes, it does, go through all different elements, if you will, of a person's life while they're at Willowbrook. But and to me anyway, the opening of the Willowbrook consent judgment, when it talks about looking at people, is it's like the Declaration of Independence. I mean, it really is. It is a beautiful, beautiful document. I'm just, curious. I mean, when you were sitting around and litigating it at the time, do you think you were going to get there and as quickly as you did? I mean, frankly, 3 years into that lawsuit, you were walking away with a pretty significant victory.
We always thought we were going to win legally. We were never sure we were going to make any difference. Winning the court order doesn't accomplish anything except gives us something on our resume. But we were never entirely sure that we could make the consent decree really mean something.
It also means that every legal organization that has lawyers has to find a way to fund those lawyers working on the Willowbrook case. And one of the reasons that the permanent injunction was written the way it was to make sure that the NYCLU and New York Lawyers for the Public Interest 5 or 10 years later wouldn't get tired and say that we don't need people like Beth anymore, or Chris.
I would say on behalf of the state, I suppose we always thought we were going to lose, except that we were being directed by a governor, one of whose prime campaign promises was to bring a just resolution of the Willowbrook litigation. But once upon a time in front of Judge Bartels, I compared the way a state accomplishes things as being like a cow, in the sense that the cow eats, the cow then ruminates, regurgitates, chews everything again, and in the utter fullness of time, it produces things, one of which is milk. It was always going to be a thing that it would take time to accomplish. And if you look at the election cycle of governors and presidents, you really have to accomplish, you have to accomplish the things you promised to accomplish within 3 years, because that 4th year, you've got to run again. So, why would you bother to have a 7-year plan? I mean, unless you weren't serious about it, I guess, because you won't accomplish it in time to take credit for it and get elected again.
I just want to tell a quick anecdote. I was at a biennial conference of the ACLU my first year, I think, as a lawyer. And Roger Baldwin, who is the founder of the ACLU, I think was 96. And he was standing there, Chris you might have been there too, was standing there with one of his colleagues who was a lawyer for the Indiana Civil Liberties Union, who was 95. And they all looked at us. It was the beginning of the Burger Court, and we were all depressed and thought, no more litigation in federal court. Let's go to the state courts. And he looked at us and said, you have to have patience. You don't understand. We fought 40 years to get rights for unions to organize. People were being shot in the streets, but we got those rights. We got them. You just be persistent. You'll get them too.
That is, the $1 million question. I mean, trying to bring in New York City, for example, to Rikers, the federal DOJ, right? There are consent judgments around the country relating to individual state correctional facilities. That requires, again, complete dedication. There are families, there are advocacy entities, legal advocates, formerly incarcerated individuals who are out there advocating. But it is a very, very heavy push. When DOJ came into Rikers, they only went into the juvenile adolescent wings. We're not able to muster a response to the adult units.
I want to add to that, every time something goes bad, like the Prison Litigation Reform Act or like the hostility of the courts, it's the job of people who had the jobs we have, and that still has, to figure out a way to get around that.
Yep.
We had great jobs. We had really wonderful jobs because we got a chance to say, okay, they hit us in the face. How do we get around that? And the lawyers who are doing it these days, they'll find a way around.
Yeah, our job is generally to go into the office and bang your head against the wall until you figure out a way to get into court or to, at the NYCLU, right, we do sort of multi-platform work. We do a combined public education, legislative, policy advocacy, organizing, and litigation. And if you push hard enough, there will be a way to break through. And the question is identifying it and marshaling all of the people resources that are necessary. I mean, the entire disability justice world comes out of a medicalized model. So it's diagnosis driven, right? So dementia is in a particular age category, right? TBI doesn't necessarily qualify you for OPWDD services, right? You have to have cognitive impairment that manifests before the age of 21. And people are being screened, diagnosed out of that. For services in correctional facilities, you have to have severe mental illness, SMI. That's not even a diagnostic term, but it gives enormous ability to, correctional staff to determine that a person doesn't have SMI and so should not be treated in accord with disability protections, right? So it springs from, I think, the entire construct being a medicalized model of disability determination. So, you could sort of say, okay, the ADA needs to be thrown away, but you don't want to touch the ADA. There are too many challenges as it is.
I would add to that. I think, maybe that is a disability discrimination type of lawsuit might be viable, because I think just up in Albany, we see probably one a week or one every couple weeks, people coming in who's aging out of their educational program, kids are being denied OPWDD services. Some of them, many of them, in fact, are not even looking for residential services. I have at least a degree of sympathy with them because they can't get people to show up to work, and neither can many voluntary agencies. But people, they're requiring levels of documentation and that sort of thing, and trying to drill down to prove that kids, I keep saying kids, but I mean young adults, disabilities are of this nature or that nature, when it's clear that what they need is a program of services to get them over to the hump so they can be employed. They can be usefully, employed. There is a very small I know her name, but I'm not telling anybody else or or her phone number. But at the Council of Children and Families, a very small state agency, they have a difficult to place, difficult to serve unit with a couple of women that work there, and they're terrific. If you can manage to make contact with them, they actually know phone numbers. I don't even know anybody's phone number at Access VR over in the state ed department. But I think you're right. I think, you know, that the state is now weaponizing screening, you know, in a certain way to keep people out of services. And the other thing, of course, that they're doing, they have in the course of implementing the home and community-based services waiver, they've stripped almost all of the clinical services out of community residences. And I mean, I'll bet it's as big a problem here in Manhattan as it is in Malone, New York. It's just really tough. And when you have to send somebody to the hospital and they're at least arguably ready for discharge, you would think what you'd be coming up against is the safe discharge provisions ensconced in the public health regulations and the federal hospital regulations. But apparently OPWDD goes around making phone calls to hospitals saying, you can ignore those because we'll make the community facility with 7 beds take the person that needs to be tube fed, that self-extubates, and this and that and the other. It's you know, like needless and pointless. I mean, you know, I don't know what to tell them to do about it, because I know that some of the people that are there and I think they're good people, but I think you raise a point.
Unfortunately, we've got to end this. It's 8 o'clock. And that's our agreement here. But I want to thank everyone for the audience. And this wonderful panel, you guys are terrific, and to pick up on what people have said here and thanking you. I've always looked at the Willowbrook litigation as I mean, from a lawyer's perspective, it was great work. And we are, as a parent now, I am so indebted to you, all of you people here, because you made our lives different. And you made my daughter Julia's life very different. So for that, a personal thank you, and thank you on behalf of everyone.